SwayamPrabha. Digital India. Educated India.
Greetings to one and all. Again, I would like to welcome you on the Laws of Bank and Negotiable Instruments lecture. And this is lecture 18. I am Dr. Raju Maji, Assistant Professor, Faculty of Law, Banaras Hindu University. Dear friends, I am going to discuss with you a very important chapter, and that is Consumers' Grievances and Redressal. Before going to discuss this particular lecture, I'd like to recall the certain things which we have already discussed. The one thing I have told you that the banker's liability towards his customers is, you can say, the huge liabilities nowadays. The reason behind it, because the bankers is extending the various kind of services to his customers. Now, it is very natural that when he is rendering the various kind of services, so naturally he is also inviting the various kinds of problems also. So, how it can be redressed? For that purpose, I have decided to discuss with you that what are the grievances is available in the hands of the customers and how these are redressed by the bankers. No doubt, as you have seen that as the banker's first and foremost duty is to return money of its customers, which you have already discussed. But at the time of rendering its services to its customers, most of the time we've found that the bankers are having sorts of, you can say, the problems, and that problems has to be sought out. And as a customers, that we always expect from the banker that there will no any kind of, you can say, the loopholes or the shortfalls at the end of the bankers. But the bankers is also a human being. It is operated by the human being. So naturally, there may be some sort of, you can say, the shortfall or you can the shortcomings, and we will try to discuss in this lecture all these things, how the Reserve Bank, or you can say the banking companies, or on the other hand, we can say what kind of the redressal mechanism is available in the hands of the banker. No doubt, as I have told you that the sole guardians of any kind of, you can say, the transactions which is rendered by the banking company, that is watch, or you can say the Reserve Bank is the watchdog of all kind of activities of any banking company. So naturally, the liability lies to the Reserve Bank of India also to take care of all kind of, you can say, the shortcomings, or you can say the bad practice which is adopted by the banker. And whenever the banker is failing to render its service, what is expected, or it will better to say that what has been promised to the customers, that has to be met out. So in this regard, by keeping these objectives, this lecture discusses the various consumers redressal forum like Reserve Bank of India, the Banking Ombudsman Scheme, and the Consumer Protections Act 2001-9. Now see, that it's my question that I have told you the relationship which is very important between the banker and customers. And we know that there are primary relationship, the secondary relationship, and the special relationship which you have already discussed about it. So while undertaking the various financial transactions and rendering various services, the banking personnel came into contact with the numerous persons belonging to the different strata of society and having diversified needs, tempers, mode, preferences, while bank dealing with all the things with its personnel. And it is very important that the extra cautious, careful and courteous as interpersonal relationship is very important in a banking organization. There are several reasons which highlight the significance of cordial relationship between them. Now, Let me explain you that whenever we are talking about the relationship between the banker and customers, no doubt the one way when we are expecting the certain things from the banking companies as a customers, then it is our duty as a customers that we'll have to help the banking sector also. For example, one thing which I like to cite before you, as far as the way I'm talking with the cordial relationship is very important. The first and foremost thing, the cordial relationship which we are talking about, that means as a rights when we are claiming towards the banker as a customers, then at the same time the bankers is also expected some sort of the duties must be performed by its customers. Unless and until there is a cordial relationship between these two, then we cannot expect the best outcome. So to get the best outcome, it is very important that all kind of the services which is rendered by the banker company with some sort of, you can say, the precautions or you can say the guidelines which is made by the banking concern, it is the duty of a customers that the customers must take all sorts of, you can say, the guidelines, and it must follow the guidelines which has been made by the banking company to its customers for their security purpose. Now let me tell you the one thing which is very important. As I have told you, the banks are now functioning in a highly competitive environment. So several branches of different banks compete with each other in the same business, in a same residential area. If customers is not satisfied with the services rendered by or the behavior of the bankers' employees, they are at liberty to switch over their banking transactions to another bank. The bank who loses the customers loses all business from such customers. As earlier I have told you that the bankers has given the various kind of services, and the bankers can engage all kind of services unwillingly. If I'll say the unwillingly way I'm telling you, the unwillingly means that because as a banker it is not necessary. But the bankers, they'll have to survive in the competitive era, and to survive in these competitions, they'll have to develop themselves. And unwillingly, I'm telling you, they'll have to engage all sorts of businesses, which businesses can be done or where the banker can engage himself according to Section 6 of the Banking Regulations Act. If any bank, if he is not rendering all sorts of service which he can engage himself according to Section 6 of the Banking Regulations Act, naturally he is going to lose his customers, because the customers will prefer to go where every kind of, you can say, services is available. So naturally the bankers are compelled to engage themselves in all sorts of services. Now, as the establishment of cost of a bank branch is almost fixed, as they have to pay regular salaries to their staff and incur other expenses regularly. The profitability of a bank, therefore, depends upon the volume of business undertaken by the branches. If the customers are not satisfied with bank, the latter will be deprived of the revenue which it might have earned by rendering various services to such customers. As I have told you that the services, not only the services, the prompt services is very important. If you are chosen, the services must be provided, but these services are not properly rendering, or if you are not properly providing to your customers, so again you are going to lose. That means you'll have to pay, you'll have to appoint the efficient, or you can say the sufficient number of skilled the workers, so that they can render your services in a very prompt manner, efficient manner, so that the customers will satisfied by the services which is rendered by the particular bank. Now, in this regard, the Reserve Bank of India also concerned with safeguarding the interest of bank customers. The issue is directed to the bank from time to time about the practices they have to adopt for the convenience of the customers and to safeguard their interest. If the bank doesn't comply with these directives or codes, it may violate the Reserve Bank advice and invite its displeasure, besides spoiling relationship with the customers. As I have told you that the Reserve Bank is working as a guardian of the customers, as far as concerned, the transactions between the banker and customer. So, whenever we are talking about that, from time to time, to protect the interest of the customers, the Reserve Bank has given wide power, as you have already discussed. if you recall the section 35, if you recall the section 36 of the Banking Regulations Act, where the banker has given the wide power to scrutinize, to inspect the banking affairs at any time from their end. For that purpose, whenever he found that any sorts of, you can say, the things which is going on, which is adverse the interest or against the interest of the customers, immediately the Reserve Bank has a right that, or Reserve Bank can exercise its power that to issue some sort of the guidelines which protects the interest of the consumers. At the same time, if the consumers or customers are happy and satisfied with the bank's functioning, they will find no opportunity to lodge complaints with higher authorities or take legal recourse against the bank. It will save time, money and inconvenience for the bank officials, which they can devote to their other fruitful purposes. It's very important to mention here that, again, as I've told you, that the Reserve Bank, when he is issuing some sort of, you can say, the guidelines, and if it is complied by the banking companies, naturally that you will find that the customers will get more and more satisfactions towards its banker. And when the customers are satisfied, naturally there is the less number of complaints. And when there is a less number of complaints, it's very obviously that the banking company, other staffs, they can utilize that times for the other purposes, and that will become very fruitful for any banking company. And the last things in this regard which I like to tell you, that why the cordial relationship is important. If good relations persist between the banker and customers over a period of time, bank come to know the behavior and conduct of the customer thoroughly. Thus, the chances of frauds or defaults by the customers are minimized. Very simple, the things is that if the customers are satisfied, and easily the bankers can know that what kind of the services where there is no any kind of, you can say, the complaints has been lodged by the customer's end. So naturally it will give some sort of, you can say, the experience to the banking workers, and the banking workers will exercise that, and it will very obviously that it will help to develop a cordial relationship between the banker and customers. Now the redressal of customer grievances, when we are talking about, initially, as I have told you, there are the three kind of things which we can say. The one, that any kind of things that can be resolved by the bank itself. And the second thing is that the Reserve Bank may intervene by, you can say, the introducing or establishing some sort of the mechanisms which we will speak later on. There is the ombudsman scheme, we will talk on it. And the third thing, as I have told you, that as far as concerned, that when there is another kind of the platform which we are using, because we don't want to reach to the normal court, and it will be better that it will be redress outside the court. So for that purpose, that we'll have to see the Consumer Protections Act of 2019. So there are many types of, you can say, the grievances felt by the bank customers. Some of them may relate to the minor mistakes or irregularities or acts of omissions or commissions on the part of the bank employees. Other grievances may be in connections with serious irregularities or wrong decisions, steps taken by the bank, resulting in losses to the customers. The customers had the following options available for the redressal of his complaint. Now, the first we can see, as I have told you, that there may be the various regions. For example, that if there is any kind of, you can say, the services which have been rendered. For example, that you have provided a card, and if the card is not read by the many of, you can say, the automated teller machine, that means there are some sort of, you can say, the lacunage, or you can say the difficulties itself in the card. So in that circumstances, that it will come under the deficiency of services. For example, the another kind of the short example we can say that might be that the entries, any sorts of entries, which sometime you will find that the customers required for the various kind of, you can say, purposes. Either he is going to file, you can say, income tax return, or you can say that somewhere it can be shared that the customers has taken some sort of the loans from the outside agencies. So in this regard, he needs some sort of, you can say, the evidence proof that he has taken loan, etc. And the installment is paid through the bank. So some kind of the entries he might have required, and if it is not furnished. And as you have seen that a special relationship, when we have discussed, at the time we have discussed that it is one of the utmost duty towards the banker that the banker has to maintain secrecy. So suppose he might have disclosed any sorts of information which is not required under the law. So in the circumstances, maybe there are some sort of, you can say, the complaints might be that can be redressed. So in this regard, that I have divided the the complaints in the different level, and the complaints can be redressed through the different level. At the level of the bank concern, the first we will see, as I have told you, that it's very important that the banker is the main concern, and if any sorts of, you can say, the complaint before going to any other fora like the Reserve Bank or the ombudsman, before the ombudsman scheme, or before the Consumer Protection Act, or before the common law process, it will be better that will have to resolve it through between the parties. And who are the parties? The banker and the customers. And they are the best, you can say, the better solution can be given, or the better solution can be find out by themselves. So at the level of the bank concern, first of all, the grievance is to be brought to the notice of the branch manager, preferably in writing. If satisfactory answer is not received within a reasonable period, the matter may be preferred to the controlling office, zonal office. If, in spite of this stay, the complaint is not resolved satisfactorily, the customer may take recourse to the mechanism to set up by the Reserve Bank of India, or alternative through the judicial machinery. But as I have told you, that it is the duty of the customers that if any complaint he has towards whatever may be the services or in any issues, the first and foremost that it must be resolved through the bank itself. So for that, what he has to do, that he has to make a complaint before the bank, and the bank will give, might be that he will take some sort of the time. So within that period, if that is not resolved, so the banker has nothing to do, and the customers is bound to go for the other fora, and he may go for the Reserve Bank of India, or he may choose any other alternative mechanisms, that might be the judiciary process, etc. It is very important to mention here that at the Reserve Bank level, as I have told you, the Reserve Bank from time to time, if right now, if you'll see, the most of the time the Reserve Bank, there is an ad, or you can say the message is sent to its customers as far as concerned that how he has to take precautions, as far as concerned that when he is applying or using any sorts of, you can say, the transactions with the banker. Whenever he is making some sort of the transactions, then he has to maintain some sort of, you can say, the secrecy. That things must not be disclosed. So every time you'll find the Reserve Bank in its ad, it is talking about that you do not disclose anyone, because the banker never asked to disclose any kind of the informations, whether your accounts number, whether your you can say the other kind of, you can say, the documents. The banker is not required all sorts of, you can say, the documents through the telephonic system. If the banker is required, then he will send to the notice, and he will ask you to visit the bank itself. So at the Reserve Bank level, it is very important to mention here that in the year 2006, the Reserve Bank of India set up a separate customer service department. The functions of this department include inter alia. What are the, as I have told you, that in the 2006, the reason behind it, because the internet banking started to working in a very, you can say, the prompt way or in the rapid way. That might be the reasons that the Reserve Bank found the various kind of the complaint. So for that purpose, in the year 2006, the Reserve Bank of India set up a separate customer service department. And this customer service department, the main functions are disseminating instructions, informations relating to the customer service and grievance redressal by banks, as that this customer service department, the main function is, as I have told you, that we are getting SMS alert. We are getting some sort of, you can say, the voice information through the Reserve Bank or the Reserve Bank portal, and it is talking about that the instructions are disseminated through that department only. The second is administering the banking ombudsman scheme. We will see that how the banking ombudsman scheme is working, but as far as concerned that when the separate service customer service department was established, at the time the administration of banking ombudsman scheme were taken up. Further, acting as a nodal department for the banking codes and standards board of India, and further it is talking about the ensuring redressal of complaints received directly by the Reserve Bank of India on customer service by banks. So, in that way, we can say that at the present time, the Reserve Bank of India has also taken a very good initiative, or you can say their steps, and the purpose is that thus the complaints which is received, or the complaint which is made by the banking by the customers, how it can be redressed. For that purpose, as I have told you, the banking has established the separate the customer service department. Thus, the complaints against the banks are handled in the two levels in Reserve Banks. The one that is very important, the banking ombudsman's offices handle the complaints maintainable in terms of the provisions of ombudsman scheme. That is, and the second one is regulatory departments of the Reserve Bank handle complaints that are not maintainable under the ombudsman scheme. So there are the two ways. The one, as I have told you, the first way is that the complaints will be handled through the ombudsman scheme. But now there are certain sort of, you can say, complaints that may not come or that might not be resolved through the ombudsman scheme. It doesn't mean the bank will not providing any kind of, you can say, the remedies. The bank will redress through the other scheme, that is the regulatory department of the Reserve Bank handle complaints that are not maintainable under the ombudsman scheme. So in that way we find that one, that is the regulatory departments, and other the ombudsman offices. So let us see how the banking ombudsman scheme is working. So it's a very long, but only very short, I would like to tell you that it is one of the schemes which is launched by the Reserve Bank of India in favor of the customers, and it is working very promptly, and most of the time we find that the customers are very satisfied the working of the ombudsman scheme. So we'll have to appreciate the Reserve Bank of India. The Reserve Bank of India has taken such kind of, you can say, the valuable steps, and through that any sorts of, you can say, the complaints which you have that is redressed in a very short time or in a very specific period. So let me tell you about the ombudsman scheme. So the banking ombudsman scheme was introduced by the Reserve Bank of India on June 14, 1995 under Section 35A of the Banking Regulations Act 1949. The object of the scheme is to establish a system of expeditious and inexpensive redressal of bank customers' complaints. The scheme was revised in 2002 and again in 2006. At present, the scheme is being executed by Reserve Bank of India at 15 centers in the country. The scheme covers all commercial banks, regional rural banks, and the scheduled primary cooperative banks, but excludes non-banking financial companies and housing finance companies. As I have told you that when we have discussed what you mean by the bank, at the time we have discussed that the banking and the financial institutions are different. So no doubt, as far as concerned that there may be the, you can say, the complaint, as far as concerned the financial institutions also, but under the ombudsman scheme, these are not taken into consideration. What are the taken into consideration? That is only the banking transactions or the anything which is related to the banking business. So as far as concerned that, as I have told you, that in the 1995, the 14th June 1995, that was started by the Reserve Bank of India by exercising the power which is conferred under Section 35A of the Banking Regulations Act. As I have told you, the objective is very simple, that any sorts of, you can say, the complaint which is related to the banking business that can be taken up by the ombudsman scheme, banking ombudsman scheme. And the banking ombudsman scheme, they have established at present we have the 15 centers through which they are taking the complaints from the customers, and they are trying best as far as concerned to redress in a very short span of time. And as I have told you that the ombudsman scheme is working in a very good manner. As I have told you, the scheme covers all commercial banks, regional rural banks, and the scheduled primary cooperative banks, but it is excluded from its services to the non-banking and the financial institution. How the banking ombudsman is working in this regard? It is talking about the banking ombudsmen appointed under the scheme have the authority to look into the complaints. What kind of the complaints? It is talking about the concerning deficiency in service, such as the first and foremost thing, as I have told you, that the banker, apart from its primary business, as I have told you, the banker is extending the various kind of services. So when he is extending the various kind of services, these services are these businesses are, better to say, that comes under the services rendered by the banker to its customers. So the deficiency in service is very important. So that's why that the banking ombudsmen appointed under the schemes have the authority to look into the complaints. What are these? They are the concerning deficiency service, such as the non-payment, inordinate delay in the payment, collect of checks, drafts, bill, etc. The second one is non-issued of drafts to the customers and others. The third one is non-adherence by the banks branches to the prescribed working hours. The fourth one is failure to honor guarantee letter of credit by banks. And the fifth one is claims in respect of unauthorized or fraudulent withdrawals from the deposit account. Further, it is talking about the complaints regarding the operations of accounts maintained with banks. The seventh one is the complaints from exporters in India. The eighth one is complaints from non-resident Indian having accounts in India. Now let me come to the first one. As I have told you, that the deficiency of service. When we are talking about the deficiency of service, that means the non-payment. The payment means as a banker that he has to make payment on the demand. And the second one is if there is inordinate delay in payment. So nowadays, you know that the payment systems are very prompt because they are using the every kind of, you can say, the investigation. They are using what? They are using the computer. So by clicking a button, immediately you can find out the details of the customers, availability of the funds, and on the basis of that you can verify the signatures also. So it's very easy. So that means the customers are expecting that the payment must be made without any kind of the delay. In the same way that, as we know, that there is a concept of the clearing house. So the check can be cleared within an hour. So the customer is also expecting that check must be collected, the draft must be collected, or the bill of exchange must be collected in a very short time. So that is expectation. So the non-issued of drafts to customers and others, the draft is one kind of, you can say, the very easiest way to make payment the others. So as far as concerned, that it is very important duty towards the bankers or to render the services as far as concerned to issuing of drafts. The non-adherence by banks branches to prescribed working hours, that the workers must be available during the every working hours, and so that the customers may get the services from its bank. Failure to honor guarantee letter of credit by banks, claims in respect of authorized fraudulent withdrawals from the deposits account, the complaints regarding the operations of accounts maintained with the banks. As I have told you that there is a duty towards the banker that he has to maintain the secrecy. So if the complaints regarding the accounts which is not maintained properly by the banking authorities, the complaints from the exporters in India, that nowadays when we will discuss about the foreign exchange management, at that time we will discuss that the complaints from the exporters in India, if any sorts of the complaints from the exporters in India, that can be taken into consideration through the ombudsman. And the lastly, as far as the deficiency of service, it is talking about the complaints from the non-resident Indian having accounts in India. The non-resident of India, if they have an account, and if any kind of the deficiency of services, that has to be taken into consideration by the ombudsman. Now, the second kind of, you can say the grievances which can be made before, or the complaint can be lodged before the ombudsman, that is concerning loans and advances in so far as they relate to the non-observance of the Reserve Bank directives. Now, let me tell you that the second very important things, as far as concerned, we know the bankers, the main or primary functions is to receive deposits and to lend and invest money. So, when he is lending or investing money to the others, that has to be made in a very prompt way. Now, the third concern is that the new grounds of complaints with effect from the January 1 to 2006. What are these? The credit card complaints, the failure in providing the promised facilities. The third one is non-adherence to the fair practices code as adopted by the individual banks. The fourth one is levying excessive charges without prior notice. The next one is the new grounds for the complaints lodging during 2008-2009, that is deficiency arising out of the internet banking. And the next one is non-adherence by the banks to the provisions of the fair practices code for the lenders or the code of the bank's commitments to customers issued by the banking codes and standards of the boards of India. Now, the last one, as far as concerned, the things which can be taken by the consideration by the ombudsman scheme, that is non-observance of the Reserve Bank guidelines on engagement of recovery of agents by banks. But at the same time, I'd like to mention here that, but the scheme doesn't include certain banking transactions such as failure to honor bank guarantee or letter of credit. Now, let me tell you that how this the complaint can be lodged before the ombudsman scheme. It's very important as a customer. The procedure are laid down. The first one is if the bank concerned doesn't resolve the complaint of one customer relating to any of the aforesaid matters within the period of 1 month, he can approach the banking ombudsman of his area. The second one is if the matter is pending or decided in any other from like court, tribunal or consumer forum, or was earlier decided by the banking ombudsman, no complaint on the same subject to be entertained. And the third one is he first tried to promote a settlement between the parties. The fourth one is if no settlement is reached, he will make a recommendations which will become binding after being accepted by both the parties. And the fifth one is if his recommendations is not accepted, he will proceed to make an award. And finally, the step is in case of the credit cards, loss of complaints time and expenses and harassment and mental anguish suffered shall be taken into consideration for awarding compensation which shall not exceed rupees 1 lakh. Let me finish this, then I'll discuss again. In 2002, the banking ombudsman was also empowered to act as arbitrator for resolving disputes between a bank and its constituents and also between the one bank and another bank. But in 2006, the arbitration options in respect of interbank disputes has been withdrawn. So now, the first and foremost thing which I like to share with you that is very important. Again, that even the ombudsman scheme, it is also talking about what? It is talking about that the matters should be resolved through the parties itself. When we are talking about the party, that means first you will have to go to the banking company. When you are going to your banking company, that means that when the customers are reaching to its bank, and if the bank authority is not resolving it, and for that purpose, the time limit has been given. It says, if the bank concerned doesn't resolve the complaint of any customers relating to any of the aforesaid matters within a period of 1 month, he can approach the banking ombudsman of his area. That means the first and foremost thing is again that the ombudsman scheme is also suggesting that the first thing which I have mentioned before you, that you'll have to resolve, the things must be resolved between the parties. That means the first you'll have to approach your bank, and when you have approached your bank, and if the bank has not resolved your problems within a period, what is that? The period has been mentioned under this, the 1 month. That means within a 1 month, if the matter is not redressed or the matter is not resolved, in the circumstances that you can prefer a complaint before the banking ombudsman which is available in your area. If the matter is pending or decided in any other forum like court, tribunal, consumer forum, or was earlier decided by the banking ombudsman, no complaint on the same subject be entertained. Then again, the very important thing is that anything which is already decided by any other authority, like even the ombudsman's, or you can by the tribunal or the consumer forum, the same matter cannot be put before the ombudsman scheme, or it's better to say that you cannot make a complaint before the banking ombudsman. The second thing which I would like to mention before you, if the parties is aggrieved, then there is a provisions for the appeal. So I am coming to that. It says the banking ombudsman scheme has been further revised in 2007 to enable the bank customers to appeal against the decisions of the banking ombudsman if he has rejected the customer's complaint, provided it relates to the specified matter. Prior to it, customers were permitted to appeal only against the awards given by the banking ombudsman. Now, anybody agree by an award or which complaint is rejected may appeal to the appellate authority within 30 days of the verdict. The Deputy Governor of the Reserve Bank of India is the appellate authority. Now, very important thing which I like to mention you, as I have told you that 2007, before the 2007, there were no such kind of the provisions. It is only the revised in the 2007 to enable the bank customers to appeal against the decisions of the banking ombudsman if he has rejected the customer's complaint, provided it relates to the specified matter. Prior to it, customers were permitted to appeal only against the awards given by the banking ombudsman. Now, anybody agree by an award or which complaint is rejected may appeal to the appellate authority within 30 days of the verdict. The Deputy Governor of the Reserve Bank of India is the appellate authority. Now, it's very important to mention here that means the matter which is decided by the banking ombudsman that can be appeal can be preferred before the appellate authority. And as my question, who is the appellate authority? The answer is the appellate authority is the Deputy Governor of the Reserve Bank of India. That means you can appeal, you can prefer an appeal against the decisions which is given by the banking ombudsman within 30 days before the appellate authority. And as I have told you, the appellate authority means the Deputy Governor of the Reserve Bank of India. Now, the second things, the things can be referred before the, you can say that at the court level. If the stake of the consumer is large and the complaint is serious in nature, the customers can file a suit in the civil court or in a criminal court, but it involves a lengthy procedure and is expensive too. Hence, the alternative is to file a complaint under the Consumer Protection Act 2019. As I have told you that either you can go before the ombudsman. It's a very good scheme which has been made under the by the Reserve Bank of India. And as I have told you that even if you are agree by the decisions of the banking ombudsman, you can prefer an appeal before the appellate authority. So, in that circumstances, we find that it's a very good forum to redress your complaints. But even if you are dissatisfied with that, or if you are not satisfied, or the nature is a very serious kind of, in the circumstances, you can prefer a suit before the criminal or before the civil court. But before going to that, because this is a lengthy process, it's a time-taking process. In either court you will go, it's a time taking, and not only the time taking, it's expensive also. So the customers has to prefer the alternative one, and the alternative is the Consumer Protection Act 2019. Now, the Consumer Protection Act 2019 came into force on 9th August 2019, replacing the Consumer Protection Act 1986. It was enacted with the objective that to provide for protections of the interest of the consumers, and for the said purpose to establish authorities for timely and effectively administration and settlement of consumers' disputes and for matters connected therewith or incidental therein. So it is very important to mention here that this specific act has been made for what? For grant some sort of, you can say, the security or to provide the protections of the interests of the consumers. When we are talking about the interests of the consumers, so we'll have to see whether the services which has been rendered by the banking company that will covered under this act. The answer is the yes. Under the act, the service term has been defined under section 2 subsection 42, which includes the banks also, and it states that. Let me allow to read out what do you mean by the services as far as concerned the Consumer Protections Act. It says the services means services of any descriptions which is made available to potential users and includes but not limited to the provisions of facilities in connections with banking, financial, insurance, transport, processing, supply of electrical or other energy, telecom, boarding or lodging or both, housing constructions, entertainment, amusement, or the purveying of news or other information, but doesn't include the rendering of any service free of charge or under a contract of personal service. So if you'll see that in the circumstances we find that there are the various kind of you can say the services. All the services are covered, but the best thing which I'd like to mention you here, that the one more important thing, as I have told you that all the services are covered under this act, the very beautiful thing is the banking is also covered under this. So when we are talking about the banking is covered under, that means what is excluded according to the definitions. If you'll see all the concerns are covered, it is coming under the purview of the services by any persons, by any means, in what way. Even as I have told you that the boarding and lodging or both, housing constructions, entertainment, amusement, or the purveying of news or other information. Only what is excluded, it says two things are excluded. One, but doesn't include the rendering of any service free of charges or under contract of personal services. Contract of personal services. Otherwise, every kind of, you can say, services are included, and particularly I would like to mention here that the services which is provided by the banking companies that comes under these services, and once it comes under the services, that is covered under the Consumer Protections Act. Let me tell you, for what is important, what protections are granted. Of course, that we have seen the banking services provided, it is covered under this act. So what are the complaints? The complaints is the deficiency of service. So the term is defined under section 2 subsection 11 of the act, and let me allow to read out the deficiency term, how it has been defined. It says the term deficiency has been defined under section 11 of the act, that is Consumer Protections Act of 2019, and it said that deficiency means any default, imperfection, shortcomings or inadequacy in the quality, nature and manner of performance which is required to be maintained by or under any law for the time being in force or has been undertaken to be performed by a person in pursuance of a contract or otherwise in relation to any service, and includes, again I am repeating it, when we are talking about the deficiency term has been defined under section 2 subsection 11 of the act, and it says that the deficiency means any fault, imperfection, shortcoming or inadequacy in the quality, nature and manner of the performance which is required to be maintained by or under any law for the time being in force or has been undertaken to be performed by a person in pursuance of a contract or otherwise in relation to any service, and includes, what are these? Any act of negligence or omission or commission by such persons which causes loss or injury to the consumer. Again I am repeating it. Any act or negligence of omission or commission by such persons which causes loss or injury to the consumer, and The second one is deliberate withholding of relevant information by such persons to the consumer. Now, in that we find that the two things, what is that? The deficient service, it is talking about the fault, imperfection, shortcomings or inadequacy in the quality, nature and manner of the performance which is required to be maintained by or under any law for the time being in force or has been undertaken to be performed by persons in pursuance of the contract or otherwise in relation to any service, and includes. What are the very important things? Again, I would like to repeat here, any act of negligence, if that means the act is done by the negligently, or omissions or commissions by such persons which causes loss or injury to the consumer. That means with the act of the service provider, if any loss or injury causes to the consumer, that will come under the deficiency of services. And the second thing is deliberate withholding of relevant information by such person to the consumer. Now, let me tell you that the forum which has been provided under the Consumer Protections Act of 2019 is, I have told you that earlier we had an act that was known as the Consumer Protections Act of 1986 that was repealed, and the new act was enacted in place of that in the name of the Consumer Protections Act of 2019. So, the new act provides the Consumer Dispute Redressal Commission, and under this we have three kind of, earlier we had the similar kind of the things is available here, but the little bit we have changed the nomenclature, and as well as we have enhanced the what that is the value of it. So, let me allow to one by one. The Consumer Dispute Redressal Commission, when we are talking about, the first one is the District Consumer Dispute Redressal Commission, that in short we are calling it the District Commission, can entertain complaints where the value of the goods or services paid as consideration doesn't exceed 1 crore rupees. That provisions have been made under section 28 and section 34. When we will read together, then it says that the District Consumer Dispute Redressal Commission, in short we can say the District Commission. So, District Commission can entertain complaints where the value of the goods or services paid as consideration doesn't exceed 1 crore rupees. In the general we can say that how much that the District Commission has a power, that where there is the value of goods or services, where it is found that the deficiency of services or there is a defect in goods in the circumstances, if the goods or services value is less than 1 crore, the less than 1 crore, or it is better to say that not exceeding what is used here, so not exceed 1 crore rupees, that can be entertained by the District Commission. Now, appeal against the order of the District Commissions, if the person is aggrieved by the decisions of the District Commission, that he can prefer an appeal, and for that purpose the provisions have been made. The aggrieved by the order of the District Commission may prefer and appeal before the State Commission within 45 days from the date of the order of District Commission. So, there is a provisions that it is not compulsory if the persons who is made a complaint before the District Commission, and if he is not satisfied even after the decisions which he made by the District Commission, in that circumstances he can be treated himself as an aggrieved one, and the aggrieved one by the order of the District Commission may prefer an appeal before the State Commission within 45 days from the date of the order of the District Commission. So, there is a provisions that there is no doubt that if you are not satisfied by the decisions which is given by the District Commission and the matter, then you can prefer an appeal before the State Commission. The time limit has been provided that from the date of the order within 45 days you will have to make an appeal before the appellate authority, and the appellate authority is the State Commission. The second, the forum which will have under the new act, under the Consumer Protections Act of 2019, that is State Consumer Dispute Redressal Commission, that can be called in a short, that is the State Commission. Like the District Commission, it says can entertain complaints where the value of the goods or services paid as consideration exceeds rupees 1 crore but doesn't exceed 10 crore. So, again I am repeating it. The State Consumer Disputes Redressal Commission, that is State Commission, the State Commission can entertain a matter up to what? The amount which is not exceeded the 10 crore, that the provisions has been discussed under sections 42 and 47. Again I am repeating it, like the district commission, the district commissions we have seen that the value of goods and services to what extent? That not exceeding 1 crore. Here it is talking about from 1 crore, but doesn't exceed the 10 crores. So 1 crore to 10 crores, up to 10 crores, not exceeding 10 crores, that the value of goods or services, the complaint can be made before the State Consumer Dispute Redressal Commissions. And similarly, like the district commissions, if anyone who is aggrieved by the order of the State Commission, the aggrieved by the order of the State Commission may prefer an appeal before the National Commission within 30 days from the date of the order of the State Commission. One thing again I would like to repeat here, that as far as concerned the State Consumer Dispute Redressal Commission, that is State Commission, the State Commission can entertain a matter the which goods or the services value is 1 crore to not exceeding 10 crores, that can be preferred before the State Commission. And when it is decided, and even the decisions which is given by the State Commissions, if the persons is feeling that he is aggrieved by the decisions of the State Commission, he can prefer an appeal before the National Commission. But as far as concerned that when we are talking about the time limit, then we find the time limit has been reduced. In the previous case, in case of the District Commission, we have seen that from the date of order, how much time is prescribed? The 45 days from the date of order. But in case of the State Commissions, the appeal can be preferred before which? Before the National Commission. The time limit has reduced from the 45 days to 30 days. Now the third, the forum that is talking about the National Consumer Dispute Redressal Commissions, National Commissions, that is known as the National Commission. The National Consumer Dispute Redressal Commissions, as far as concerned that when I am talking about, then naturally that is talking about that can entertain complaints where the value of the goods or services paid as consideration exceeds rupees 10 crores. The rupees 10 crores, and the details provisions has been described under section 53 and 58 of the Act. Let me tell you that as far as concerned that the value of the goods or services paid as consideration exceeds rupees 10 crores, means up to 10 crores can be entertained by the State Commission. But as far as concerned that once that it exceeds the 10 crores rupees, that can be entertained by the National Consumer Dispute Redressal Commissions only. And as far as concerned that if any persons who is aggrieved by the decision of the National Commission, the party may prefer an appeal before the Supreme Court within 30 days from the date of the order of the National Commission. So that the deficiency service, if it is not done through that, then the provisions has been made that even the customers are free to rush towards the common law process. They have a right to lodge a complaint before the civil court or before the criminal court. But as I have told you that when the customers are rushing or the customers are going towards the normal or the common law redressal at the time, the two things is very important, that it's a time-taking process. It takes time to reach to the conclusion, and the second one, I think it's very expensive also. And sometimes we find that even the customers are not aware about that where they'll have to go. So for that purpose, that the very important initiative has been taken, and that the bankers is also included under the deficiency of services. And as I have rightly mentioned before you, that when the bankers is rendering its services, these services are, there are some sort of, you can say, the services which is commonly provided by the bankers to its customers, where we find the deficiency of service as far as concerned, the definitions which is made, as I have read out before you. Again, I would like to recall you that unlawful dishonour of check. Whenever the check has been presented by the customers before the banker, it is the duty of the banker to take it very seriously, and he has to ensure that there, whenever he is returning, then he has to mention the reasons. It is very important. If negligently he acts, that will come under the deficiency of service, and he has to compensate the customers if any loss occurred due to his negligent act. So similarly, that the negligence in collection of checks. The third one, the negligence in case of the safe deposit lockers. As I've told you, nowadays the bankers is providing the lockers facilities. As far as concerned, when we are talking about the lockers facilities, that the rights has been conferred, what we can say, that the rights will appear between the bankers, customers as a bailee and bailer, and the contractor will apply, and according to section 151 of the Contract Act of 1872, the liability has been made to the bankers as a bailee, and he has to discharge accordingly. So the further, the negligence of issuing the demand drafts, negligence in case of the guarantee, in case of the granting advances, and negligence in remitting a premium of the insurance company. The one very important things which I like to mention you for your ready reference, that no liability of banker in case of the employee's illegal strike. I would like to mention one case before you. In Consumer Unity and Trust Society, Jaunpur versus Chairman of Managing Director, Bank of Baroda, Calcutta, and another. In this case, the Supreme Court observed that the banker from any liability if the bank could not function and render any service to the customers to illegal strikes of the employees beyond the control of the bank. The Supreme Court held that the failure of the bank to render service could not be held to be give rise to claim for recovery of any amount under the Consumer Protections Act as a deficiency of service, as there was no negligence on the part of the bank. So as I have told you, that the certain act which is beyond the reach, or you can say the beyond the control of the bank, in the circumstances when the bank is unable to discharge its service, as I have told you, the case, the Consumer Unity and Trust Society, Jainpur versus the Chairman and Managing Director, Bank of Baroda, Calcutta, and another, where the Supreme Court very clearly said that if the workers are in illegal strike, naturally the bankers is not in a position to provide the services. In the circumstances, that cannot be held that it is the negligent part of the bankers, and if any loss occurred in that circumstances or the situations, the banker cannot be held liable at the end. I'd like to mention here that they still that we have the different kind of the provisions provided as far as concern the customers' grievances and redressal, but still that I would like to mention one thing, that the first and foremost thing that the matters should be resolved by between the parties itself, that the customers must reach to the bank itself to lodge any sort of complaint. As I have told you that it is not redressed by within a month, then you have you can prefer before the ombudsman scheme. And even if you are agreed by the decisions of the ombudsman, that you can prefer an appeal before the appellate authority, and the appellate authority is the deputy directors of the Reserve Bank of India. And if you are, even if you are feeling that you are aggrieved, then you can prefer the another forum which you'll have, which is protected under the deficiency of services, and the deficiency of services is protected under the Consumer Protections Act of 2019. The forum which you have seen, and it's a very beautiful, and I hope that if this forum will act in a very prompt manner, I don't find that there will be any kind of the dissatisfied the mechanisms which is provided, or the mechanism which is able to redress the grievances of the customers' end. Thank you very much.